3, 2, 1, start. This appeal has been filed against the impugned judgment of the Delhi High Court dated 6/9/1999 in LPA number 375 of 1999, by which the judgment of the learned single judge of the High Court dated 26/5/1999 dismissing the writ petition was upheld. Heard learned counsel for the parties and perused the record. The appellant is a company registered under the Indian Companies Act and is engaged in the manufacture of fertilizers and chemicals. One of the products it produces is single super phosphate. Till 1976, the manufacture and sale of SSP was not controlled by the government. However, from 1976 to 1982, the manufacture of SSP was subjected to a system of uniform subsidy whereby each manufacturer was given a uniform rate of subsidy. In the year 1982, the Government of India brought SSP under a formal price control known as the Retention Price and Subsidy Scheme (hereinafter referred to as RPS) for regulating the price and sale of SSP. The scheme had been introduced on the basis of a detailed study and recommendation of an inter-ministerial working group appointed by the government. Under the RPS, the manufacturers were obliged to sell their fertilizers at a subsidized price fixed by the government, which was below the cost of production. The respondent number 2 calculated the cost of production of each unit on the basis of certain factors such as capacity, location, age of the plant, etc., and added a certain amount of national profit, and the result was called the retention price. The difference between the retention price and the selling price as fixed by the government was calculated and paid to the manufacturers as subsidy. Thus, while price of the fertilizers for the consumers, namely the farmers, was subsidized by the government, the manufacturers were given an amount which was calculated by the FICC on the basis of normative cost of production of the unit, which was to be calculated on the assumption that the unit performed efficiently at 90% capacity utilization. On 15/1/1986, the Department of Industrial Development, Ministry of Industries, issued Press Note number 1, whereby the capacity indicated in the industrial license could be reconsidered with reference to the highest production achieved during any of the previous 5 years plus 1/3 thereof, provided that was within the licensed capacity plus 25%. Thereafter, the Department of Industrial Development, Ministry of Industry, issued Press Note number 9 (1988) series on 6/4/1988 with effect from 1/4/1988, which provided a scheme for re-endorsement of higher capacity of the fertilizer units. Under the said scheme, the unit could apply for re-endorsement of an enhanced capacity on the basis of the best production actually achieved in any financial year between 1/4/1988 and 313/1990. In accordance with the above-mentioned press note of 1988, the appellant wide application dated 8/8/1988 applied to the Ministry of Industries for re-endorsement of the capacity of the appellant unit on the basis of the actual production between 1/4/1988 and 31st/3/1990. Thereafter, the respondents asked for several verifications which were provided by the appellant. Stop.